Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody. Thank you for joining us today for our firm's February live virtual First Friday event. So happy to have you here with us. Hope you had a great January and looking forward to a good February ahead of us. Looks like we have, we're a lot of people joining, up to 33, 35. So thanks everybody for being here today for our firm's February live virtual First Friday event. So happy to have you here. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. I wish you and your association a healthy and prosperous new year ahead. If you're just joining us for the first time this year, we have a lot of great things to talk about this year, including the Arizona legislature's in session and a new federal law which applies to associations, which we're going to just briefly touch on today. Just some background information about myself is that I've worked with, as their legal counsel, HOAs and condominiums in the state of Arizona for the past 27 years. Can't believe it's been that long. It's gone by really fast. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. So I think I bring a wealth of experience to answering these questions the first Friday of every month, because not only am I an attorney that specializes in representing associations to help them with their legal issues and legal questions, but I've also served on my board for many years, over a decade now, to help my community, basically. And so I understand the challenges of serving on the board. And of course, I've also been a homeowner when I wasn't on the board. So I also understand how that works and how that sometimes can be frustrating too. We have a great presentation planned for you today. Looks like we have over 40 questions, which is amazing. Welcome to our firm's live virtual First Friday event for the month of February. Remember that First Fridays are a great time to get your questions on Arizona HOA and condo law answered for free. Here's how First Fridays is going to work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will answer all questions between now and 10 a.m. Just a quick friendly reminder, because we get a lot of questions this morning, 40 plus, this free opportunity is limited to one question per association. If you plan on submitting a question live during this session, please include the name of your HOA or condo and your current role, such as, are you a board member? Are you a homeowner? Are you a manager? When you submit your question. Thank you for understanding. It helps us to quickly move through these questions. And also try to be as clear as possible when you're asking the question, because there really isn't any opportunity for follow-up in a virtual event like this. Okay, we're going to talk about two things very quickly before we get into the questions this morning. The first thing is Arizona legislature is in session. It's, they're about 4 weeks in or 3.5 weeks into the legislative session for 2024. And as of this morning, we have over 1,600 bills that have been introduced by the Arizona legislature this year. That's a lot. I've been filing legislation for many years. That's a lot of bills for this time of the year already. Our firm is already tracking 28 bills that directly impact HOAs and condominiums. From my perspective, this is a record number of bills that pertain to associations. Some of them are duplicate. So as we're going through each bill as every week to see what's happening in the legislature regarding HOAs and condos, because we know that you're all interested to find out what's coming up the pike. Some of the bills that have been introduced this year are duplicative, but the topics for the bills this year are how to increase assessments, some additional restrictions on that, annual meetings, open meeting law, additional requirements for the open meeting law, records requests, several technical correction bills, one on condo interior improvements, short-term rentals, corporation commission, online lodging marketplaces, which I think is kind of similar to short-term rentals, having meeting agendas, liens, declarant control, flags, weird one on the revolutionary flag being allowed in an association that's been introduced in this legislative session forum, and then some other topics as well. So we're going to be sharing with you, just because we don't have enough time this morning to go through all 28 of these bills, we're going to be sharing with you our first summary of 2024 of the 28 bills that are pending in the legislature right now. Now, again, just a reminder, these bills are not the law. These bills have just been introduced. They will have to pass both chambers of the Arizona legislature to become law, and then they'll have to be signed by the governor. So we've got a long process ahead of us. And, last year in 2023, we got 5 bills after I think 20 bills were introduced. So I think it's going to be a larger legislative year in 2024. And you can come to us as a resource because we will be posting updates frequently on our website regarding the summary of the pending legislation. So check our website every week, and we'll be letting you know which bills are moving and which bills we think have a high probability of passing this year. And then, as always, at the end of the legislative session, what we will be doing is we will be giving you a summary of the bills that do pass and become law, and then the effective date of the law. So usually, if you're checking back with us around May or June, the final bills will be getting really close to having the final bills for the end of the legislative session. So stay tuned. Okay, another thing that we are closely watching is the Corporate Transparency Act. And that is a federal law, and that is already the law now. So fortunately, the reporting requirements for this law, so taking action, associations won't have to take any action on this for 11 months or 10 and a half months, basically. But we do want to make you aware of it. It's just a really weird outlier law that I think never should have applied to associations. And basically, I'm just going to spend a minute on it, and then we're going to share some articles with you that I think will be helpful as you're becoming familiar with the law. Now, again, we're introducing it now, but the reporting requirements that are required under the law, which is the main purpose of the law, those won't be going into effect until January 1st, 2025. So we have time. Basically, this is just a federal law that was passed in 2021 to track criminal or terrorist money laundering. And the goal of the CTA was to safeguard national security and the U.S. financial system. How HOAs and condominiums throughout the U.S. are subject to this law is something that I'm still scratching my head on. I do not understand why we are having to comply with this, but it is what it is. And sometimes in life, you have to accept and, move on. And this may be one of those situations. We're hoping or are hopeful that the legislature is going to realize that charitable organizations and nonprofit HOAs and condominiums throughout the U.S. really shouldn't be subject to this law, and will amend it before the reporting requirements start. But basically, the short answer is yes, this does apply to HOAs and condos throughout the U.S. There is a small exception, like if you don't collect any assessments, that it may apply to you. But there are reporting requirements. You're going to have to tell information about your key personnel in your association, et cetera. And we're sharing with you right now 2 articles that will be helpful as you navigate this. We also just wrote a blog on this and did a Mulcahy memo yesterday on this as well. So there's going to be a lot of information over the next 10 and a half months on this. But bottom line is, are you subject to it? Most likely, yes. The reporting requirements, require us to provide information about the association, including board members' names, their birth dates, their home addresses, identifying information like their driver's license, state IDs, or passport numbers. And anytime there's a change in the board, that will need to be updated within 30 days. So strange law. As of right now, you do have to comply with it. And so we wanted to make you aware of it. I know that we've also just shared our blog post with you on this that we wrote yesterday. So take a look at that if you're interested. It's important that you know about it, but we don't have to take any urgent action right now. So just introducing it, and we will continue to talk about that law and the new legislation over the rest of 2024. So stay tuned. Okay, let's pop right into our questions. It looks like we have 40 plus questions this morning, which is amazing. I'm just going to look at the final number just so I can get myself psyched up for a big morning of answering questions. Okay, we have 44 questions, which is awesome. The first question we have is, you mentioned something about how we all have to allow group homes in a planned neighborhood or planned community. We have something in our CC&Rs that states, under the use restrictions, no hospital, sanitarium, hotel, motel, or any kind or nature shall be permitted or maintained on the lot, including any building that can be used for the care, lodging, or entertainment for hire of persons suffering from any disease. My question is, doesn't a group home, which you were mentioning that we have to permit, fall under this section in the CC&Rs, which appears to allow a group home? Our documents were created and signed in January 1994. Okay, a couple things. So under federal law, there's a federal law called the Fair Housing Act, and there is a specific requirement under the Fair Housing Act that associations have to allow group homes for, certain individuals that meet the criteria. Probably the most common group home that we see is a group home for the disabled. And so I'm going to be sharing with you right now our cheat sheet on federal laws and also our blog on group homes so that you can take a look at that in more detail. But the bottom line is it doesn't matter what your CC&R say. This federal law trumps your association's documents, and you need to comply with the Fair Housing Act. And therefore, if a group home wants to move into your community and they are one of the group homes that is allowable under Arizona law, your association cannot prohibit it or fine them or put them in violation status for this. If you want more information, please be sure to check out our cheat sheet on this topic and our blog on this topic. And you're always welcome to follow up with our firm with any questions. There is some regulation that is done by the different cities and towns in Arizona. And so you can check in with them. They have an entire registration process that the group homes have to follow. And there's only a certain number of group homes in a geographic area, although I've never seen a group home be prohibited, honestly, in over 20 years because there's one too close to it. So it's pretty liberal in terms of how many group homes can be in a geographic area. So check out those cheat sheets. Hope that helps answer your question. Question number 2. Hello, we would like to get information on full management and what duties can be given to homeowners. For example, can a homeowner take care of collections and accounting for the HOA without being on the board? Great question. I bet if I had to guess, your association is one of those associations that has either smaller and you are suffering or struggling as a board because there's not enough people helping. And so you're wondering about what can we delegate to others in our community? Having another homeowner take care of collections and accounting for the association, that would be unusual. But I guess I have seen it like very rarely, but I have seen it if somebody had like some special knowledge, like they were a bookkeeper or a CPA or something. I guess my biggest concern is we have to have accounting controls in place so that, there's no fraud and embezzlement. And so I really would prefer that instead of delegating this to a homeowner, that you have, either a management company that does this. There are some management companies that do accounting only services, which it sounds like that's kind of what you need. Or you have a board member with expertise do it because there's directors and officers insurance coverage in the event that there's a mistake or in the event that there is any misappropriation of funds through the fidelity bond. So I think that's just kind of my comment on it. Can a homeowner take care of collections and accounting for the HOA without being on the board? I mean, in theory, yes, but in practice, it doesn't appear to be a good idea to me because of the liability. Okay, next question, number 3. Could you explain what ARS 33-1254 surplus monies means and how it should be implemented? I would just love to compliment my team right now because they copied and pasted the statute right in there for me. And I'm just really appreciate that because there's a lot of statutes that we need to know as an attorney that practices in this area. And I am obviously very familiar with all the statutes, but when you just give me a number, it's hard for me to scroll into my head and get to the right place. Okay, so let's talk about 33-1254. This is a provision in the Condominium Act in Arizona, and it talks about surplus monies. And basically what it says is unless otherwise provided in the declaration, and what that language means right there is that whatever's in the declaration controls in terms of the language, any surplus monies of the association remaining after payment of or provision for common expenses and any prepayment of reserves shall be paid to the unit owners in proportion to their common expense liabilities or credited to them to reduce their future common expense assessments. This is a provision that I don't think I've ever seen, a couple of times when there's like a special assessment or something and we have extra money afterwards, we return that to the homeowners. It's very unusual that the homeowners get money back at the end of a fiscal year. So I think we all can agree that's not something that happens often. Often, The declaration will specifically provide what happens if we do have surplus money at the end of the year. So this statute wouldn't even kick in. And every association has a different section in their declaration that talks about, what to do with surplus money. So we only use this section when it's a gap filler if your documents don't address it. But the bottom line here is, if you have a surplus of money after you pay all the expenses of the association in a condo, and you prepay reserve items, that you may have left over in your account, so you could just move the money to the reserve account, is what I mean. If you have any excess monies or surplus monies, they need to be repaid to the owners in proportion to their common expense liability or credited to them to reduce future common expense assessments. Like I said, this never happens. Usually what happens is if there's a surplus of money at the end of the fiscal year, it's transferred to the reserve, which is allowable under the statute, and it's usually not returned to the owners. But it's a good question to ask, and it's good something to have on your radar for your board. You should be thinking like, hey, do our documents say anything about this? And if they don't, this is a law that we need to be aware of. Okay, question number 4 from a board member. Is the board allowed to put up cameras without the knowledge of its residents? We have a blog on security cameras, which our firm is going to be sharing with you. So that has just kind of a good overview of what security cameras, information about security cameras and questions that we commonly get on security cameras. I guess from my perspective, the board, this should be common knowledge, right? The board should be voting on this expenditure during an open board meeting. Now, whether or not the board needs to, notify everybody in the community, hey, we're putting up cameras, in the garage and in the entrance to the pool area or whatever, I don't think that there is an affirmative obligation to do that. I'm just thinking about my association where I'm on the board right now. We recently just changed out our camera system in the past year. And I don't think we notified people that, hey, we have a vendor on the property putting up cameras, but we didn't give them a specific cameras are going here, there. Like anything, I think it's the associations that communicate the best. Guess what? They have the fewest problems. And so I would encourage boards that if you are putting up cameras, you should be communicating with your owners about it and putting a positive spin on it too, because it's a good thing. I can just say from my experience, our association in the past, we've probably had the new camera system up for 8 or 9 months. It has solved so many problems in our community, like damage to common areas, vandalism. We had, just a number of issues where bad behavior, where the cameras just busted, right? Straight up. They busted people who were, doing these things, and we were able to determine who damaged the common areas, and then we made them pay for it. So they're very helpful. So I guess, is the board, can they put them up without the knowledge of their residents? They shouldn't be putting them up, obviously, like in a privacy area where it's, like the bathrooms or changing areas. That's obviously a no-no. But I don't think they're required if they put a new camera up at the pool to tell everybody, but it's best practices to do so. Okay, question 5. Resident payments need to be in our office by the 15th to be considered on time. Please help me understand if the federal law about postmarks and payments is to be upheld. If a payment is postmarked before the due date, it must be considered paid on time by the HOA. That's a really good question. It kind of depends on how your documents are written. I think it's the way that state law says, and planned communities are the only one that have a state law in the Planned Communities Act. It just says that assessments are deemed to be delinquent if they aren't paid within 15 days of its original due date. It doesn't really talk about the federal law. I guess here's what I would say. I would go by if the payment is there by the 15th, in the lockbox, or it's been received by your office. If an owner says, well, wait a minute, I have evidence that, it was sent under the mailbox rule, which is kind of like the federal postage rule, that it's considered mailed once I put it into the mailbox, I wouldn't want to get into a litigation on that. So I probably would, if we have the evidence showing that, I probably would honor that. But the reality of the situation is we don't keep the envelopes, right? And the owner doesn't see the stamp. So they're probably not going to be able to make that argument. But it's just something to consider. We don't really want to get involved in litigation with an owner on this. But from my perspective, if it's not received in my office, even when I'm doing like a payment plan with an owner and they're paying us, if it's not there by the due date, it's late. Okay, next question, number 6. Assume a 3-member HOA board of directors that agrees to meet to address the challenges with interpersonal dynamics on an HOA-related conflict, including but not limited to legal matters. Would this meeting constitute an executive session? If not, are there any no-cost alternatives to the use of a lawyer or mediator to help ensure a private and constructive process? Okay, we're going to share with you our blog on dysfunction among board members, because it sounds like maybe there might be some issues right now on your board. Okay, so just to get to the bottom line of your question, I think that blog will be helpful. But to answer your question, you have a 3-person board. You're meeting to discuss challenges, interpersonal dynamics regarding your board, and some, disagreements that you have on legal matters. Is this meeting an executive session? Well, if you have a 3-member board and you have 2 out of the 3 there, yes, that's a quorum, and it would be considered an executive session, and you'd have to notice it. Now, the good thing about an executive session is you have to notice it, but you don't have to allow the owners to attend. So just give the notice 48 hours in advance, and you'll meet the requirements of the open meeting law. Now, the second part of this question is if it's not, and why is it an executive session? Because it appears that you're talking about legal matters. If you're only talking about personality disputes between the board members, that would need to be pushed to the open session, not the executive session. And of course, that'll be uncomfortable because then everybody's going to be listening in on that. Everybody in the community, if you have a high participation rate for your community. So your question is, if not, are there any no-cost alternatives to the use of a lawyer or mediator to help ensure a private and constructive process? Probably, no cost. So, I think what you're wanting to do, and I think I'm kind of reading between the lines, but I think what's happening here is there's some severe dysfunction on your board. And you want to talk about it quietly without having everybody in the community understanding how serious the dysfunction is. And I get that. So one thing that I would suggest is have your lawyer go to the meeting and talk with your board about this. And then it could be executive session under the advice from your attorney. So that would be one thing that I would recommend. That's a good idea. Another alternative would be to have your attorney give an opinion on it and then discuss that opinion during executive session. So that's obviously not going to be no cost, right? That is going to still be an expense because the attorney is going to be weighing in on it. And the way to do that would be to have everybody put together a summary of why they're upset or whatever, and then have the attorney, write an opinion on it. Honestly, the fastest, easiest, smartest way to get this done is just hop on a Zoom call with the attorney. Everybody talk about what the problems are and resolve it with the attorney being there. And actually, I can act as a mediator when I do that. I do that very frequently when we have boot camps for boards. Oftentimes, a boot camp is needed when there is a high level of dysfunction. Short answer is, I'm not aware of any no-cost alternative. A mediator, you can bring in a mediator, but that's not going to be legal advice that would fall under the category of being able to go into executive session. So I think probably the best idea would be to bring in a lawyer, just set a timeline on it. Say, okay, we're spending an hour on this and that's it. And the attorney will be there to help us navigate this, and we got to get right to work when we get in there. Okay, question number 7. Several residents are violating city parking rules by leaving vehicles on the road for 48 hours plus. We call our community officer, the police non-emergency number, and parking enforcement daily as they are creating dangerous blind corners in our neighborhood. Our HOA manager and members of our board are unwilling to respond to these city violations, even as they violate our CC&Rs. How can we best hold our HOA and volunteer board leadership accountable? What recourse might we consider to ensure neighborhood compliance and increase safety? Okay, so really great question. So I guess, from my perspective, there's city parking rules that are being violated. So probably this needs to be moved to the code enforcement department or the police department with each city. I'm sorry that maybe you're not getting the response that you want from them, but the HOA is totally separate, and it doesn't appear under the facts that you gave me that we are required to act on these city violations. And I think there's kind of a trend in our industry based upon the new legislation that has been passed over the past few years that even if the streets are city owned, the association is not going to be as actively involved in parking disputes or parking violations going forward. And so that is something that legislatively we're going to be addressing in the next few years, because there was a bill last year that talked about this, that if you're a planned community and it's city-owned streets, if the association wants to continue enforcing it, we have to have a meeting of the membership and have a vote on that to enforce it by a date certain in 2000. I think it's 2024 or 5, 26. I don't have it right in front of me right now, but look at our new legislation from last year, and that will give you some good information on this. But in the meantime, I think just follow up with the city, town, or municipality. And sometimes, unfortunately, squeaky wheel gets things done. And it's really not the obligation of the board and the HOA to handle this, frankly. It sounds like it's a city violation, so we typically are not involved in something like that. Okay, next question, number 8. How can HOAs manage group homes in their communities in light of the recent sober living homes fraud controversy? Okay, really great question. So I'm not actually so familiar with what's going on with the sober living homes fraud controversy. So maybe we can add that to the end, and maybe my team can give me a little bit more information about what's going on that. And then we'll address it at the end. But I'm very familiar, obviously, with group homes and what's going on in group homes. So we can help you with that. Okay, our next question, number 9. My board members and I are asking who will have access to the CTA reporting information. I don't know the exact answer on that, but it is going to be filed with the federal government. And honestly, I've been talking about this a lot in different groups that I belong to of attorneys that practice in this area. And I mean, we are all just shaking our head thinking, why are HOAs and condominiums subject to this law? It just doesn't make sense. I think kind of where you're going on this is, okay, we have to give potentially our legal name, our addresses, and our driver's license or our passport. And that's kind of uncomfortable, right? It's going to the federal government. And if you think about it, there's probably at least 2 other places in the federal government where they already have this information. So it's not like it's anything new that's being reported. And so who's going to have access to it? There's a special department that is going to be accepting the applications. And I'm assuming that will be where it starts, but I'm pretty sure because this is a law that involves money laundering and terrorist activity, I'm pretty sure there'll be other branches of the federal government that will have access to it as well. Although I don't have any personal direct knowledge of that, but it's common sense that that's probably what will happen. Okay, next question. We collect transfer fees for property sales. This is from a board member. What is the convention for collecting fees for a transfer that wasn't a sale, such as a deed change, an inheritance, or a gift to a family member or third party? Okay, so really good question. So you're asking, you collect transfer fees, and this actually kind of also applies to disclosure fees, which is another fee that is charged typically as part of a sale of a property or a movement of a property from one owner to another owner. Okay, so the question is, how do we handle the unusual transfers? The normal transfers, just so we're all on the same page, what typically happens is the property enters escrow. The title company will provide all that information to the buyer, and I'll collect all the fees that are charged at that time. But what do we do when there's no title company that's handling this? And basically, that's kind of an unusual question, right? And so what typically will happen is we find out about it after the fact because there's no title company and there's no for sale sign and we're not aware. Typically, we'll find out about it. Either somebody new moves in and somebody starts asking questions, or maybe the new person contacts the association directly. Okay, so what are some things that we need to look at if we're trying to collect a transfer fee and it's an unusual one, like it's a quitclaim deed, or it's a beneficiary deed, or it's a gift, or something unusual that we don't normally see where there's not a title company? Basically, we need to look at the language that's in your CC&Rs regarding transfer fees. Like, when does it kick in and apply? In most situations, anytime it transfers to a third party, it's going to apply unless you're doing it as part of like estate planning and it's really not like a transfer. Like, for example, my husband and I form irrevocable trust to protect our assets, after we pass away so that our family doesn't get taxed on our assets, right, when we die. And as part of that estate planning, we transfer everything, all of our properties, into an irrevocable trust. Well, you shouldn't have to pay a transfer fee on that. Okay, that's not something that is customary that you pay a transfer fee on, because I'm still, the owner, just going into a trust that we formed. But when, let's say that I'm transferring my property to my children, that could very well be a transfer fee moment that under your documents, it requires the new owner to pay the transfer fee. But again, this is document specific. So you have to look at how the transfer fee is set up in your property. Another name for transfer fees is capital contribution fees. And I would encourage you to take a look at our cheat sheet on disclosure and transfer fees, which we've already shared with you, because it outlines specifically what the requirements are under the law for both of those. Okay, next question, number 11, from a board member. What do I do when another board member leaves me a threatening voicemail? My job was to write up a response to a homeowner regarding their architectural request. Being an HOA is not all I do in life. Oh, I'm sorry to laugh, but I really do. I understand that on many levels because I'm a board member. A board member called and left me a very tense voicemail telling me how disappointed he was that I had not yet finished the ARC. He demanded I call him. His temper on the voicemail was really disturbing. I emailed back attaching the letter I sent for the approved ARC. I emailed him that I would not call him back with such a temper and to never leave another message. Honestly, I think that you handled that perfectly. I think one of the interesting dynamics of being on a board is you have different personalities, people at different ages, typically people with different life experiences serving on the board together. And it sounds like your job was to respond on an ARC request, right? And it appears you did it, but there was some sort of a miscommunication and the board member left you, a nasty message and you didn't like it. Obviously, no one likes receiving something like that. I think the way you handled that is perfect. When somebody on the board has a conflict with another person on the board, you need to set boundaries. And you've set a boundary now. Your boundary is that you provided him with the information that you had already handled. You sent him an email back saying, I'm not calling you back because of the way that you treated me in your voice message. Please don't leave another message like that for me again. I think that was a very healthy way to handle it. I'm not sure that you need to bring it up at the board meeting or get the attorney involved. I mean, I don't know what the threat was. It doesn't sound like there was a direct threat, like I'm coming over to get you because you haven't done the ARC letter. It sounds like it was more just like frustration and anger. And, sometimes different personality types handle conflict differently. And so I don't think, based upon what you've told me, that this rises to the level that you need to bring it to the attorney. Now, that being said, if this board member is behaving badly at board meetings or continues to, harass you, then this does need to be escalated to legal counsel. Okay, question number 12. When is it allowable for you to use your reserve account money? We have a really good cheat sheet on this topic on reserve funds for community associations, which we're sharing with you right now during this presentation. We also will be, you can find all of our cheat sheets, of course, always on our website at mulcahylawfirm.com as well. Okay, so when is it allowable for you to use your reserve money? Anything that's listed in your reserve study as a reserve component or a capital improvement item, it is customary that you can spend reserve money for those items. If you're going to use reserve money for something else, like let's say you need to take a loan out from your reserve account, which obviously is not advisable, you should be checking with your CPA as to, can we do this? Is it advisable? Do we have to pay it back within the year, et cetera? So the short answer is, if it's listed in your reserve study as a component, then you can use the money for that. If you do not have a reserve study, then you need to look at, maybe get advice from your attorney about whether or not the way you're planning to spend the money is consistent with how reserve funds should be spent. And, you're welcome to follow up with the question in the future to ask me, hey, is this typically something that would be a reserve item? And I'd be happy to help you. Okay, next question, number 13. The bylaws of the COA specify that an owner may only serve on the board for consecutive 4 years. 2 present members are presently serving their 4th year. They have been retaining their position due to a lack of quorum at the annual meeting. Are they eligible to serve again if the quorum at the annual meeting is not met, or must they step down? So really good question. There's kind of two options here. Because you don't have a quorum at your annual meeting, or you're anticipating that you're not going to have one, technically the way that most bylaws are written, and I haven't seen yours, but this is pretty common, is that directors serve until their successor is elected. So it's kind of a weird situation that you have right now, no quorum for your annual meeting. And so these directors have been elected, and they, unfortunately can't get a quorum at the annual meeting. So they're going to potentially have to continue serving. And yes, that does violate the 4 years, but if somebody complains about it, you can have them resign, right? And say, hey, that we couldn't get a quorum and we're happy to resign, and the board can appoint somebody to fill our vacancies. Would you be interested in serving on the board? Ask the person who's complaining. So this is kind of a problem that we see from time to time. I think kind of the bigger problem is, why aren't you getting a quorum at the annual meeting? And the short answer probably is because things are going so well, right? Nobody's complaining and there's not a lot of problems. So people aren't coming to the annual meeting. So if I were in your shoes right now and I was helping your association with this, I would say, yes, the 2 members on your board that have exceeded or will exceed their time on the board, and they'll be in the over 4-year category if you can't get a quorum, they can continue on. There's nobody else that you can't get a quorum at the annual meeting, then there's nobody else that can be elected to their position. What I would do is document everything in writing, let the homeowners know what's going on, and say, hey, if anybody is interested in serving on the board, we're happy to let these people resign who are in overtime, so to speak, on their board service. But this is the situation that we have based on our documents. You may want to consider amending your documents to get rid of that requirement for a term limit. That's an option. Another option would be to have these directors resign. Like, let's say they want to get off, right? Like, I've been serving here for 4 years. I don't want to do this anymore. They can resign. There can be a vacancy on the board, and the board can replace them, typically through a board vote. So without knowing more about if there's somebody interested in running, that could be a good solution. So let's say you have some candidates that are interested in running, and the election never occurs because we can't get a quorum. A really good switch on this would be have the directors that have exceeded their term limits resign, and then have the board appoint the candidates that want to run, or whoever the best candidates are with the best qualifications, et cetera. That's another pivot. Okay, question number 14, it looks like we're on. Okay, in January, Beth talked about the difficulty in getting volunteers to serve on the board. Our bylaws specify a 5-member board. We are a small community, and most service-minded residents have already served a term or more on the board. We have to fill a vacancy and cannot find a volunteer despite an appeal to the community at large. Can we move forward with a 4-member board despite what the bylaws say? So short answer would be yes, you have a quorum. The 5-member board, your quorum is likely 3, so you have a quorum. So short answer, yes. I mean, should you be trying to find the 5th board member? Of course. And if somebody comes up along the road, that is interested in being on it, you can always appoint that person to the board. I don't think this probably rises to the level, or I actually don't think it does rise to the level where I've talked in the past about sending a letter to the owners, letting them know that, hey, if we can't find a board, we may have to go into receiver. I mean, that's not the case here because, or receivership. That's not the case here because you still have a quorum of the board making association decisions. So is it ideal? No. You only have 4 out of 5 board members, but you still have a quorum and you can still do business. So I'm fine with it. But make efforts, like I said, to try to find that 5th board member. Okay, next question. We have 2 board members of 4 positions up for nomination at this time. Can we solicit for more to vote? Seems we have 3 guys win with a total of 34 homeowners voting out of 325 homes. I think I understand this question. Let's see. So the bottom line on this one is that you have, 2 board members of 4 have been nominated. Okay, I get it. You have a nominating committee, it sounds like, and they've only put 2 board members up for nomination, right? And there's 4 open. They've only come up with 2 people. So can the community just ask for 2 more to vote. Seems like they're claiming that the same three guys win every year. So of course, what you can do is you can have write-in candidates. Possibly you have to check with your board to see if they're going to allow write-in candidates. But also you should be saying to them, hey, I think I'm reading this right. It's a little bit confusing how this is worded, but we want more people to come in as candidates, and we want them added to the ballot. And so I'd have to look at what your bylaws say on how the selection process works for adding people to the ballot. But if your board won't let them be added, you can have them be write-in candidates if that's something that's not prohibited in your documents as well. Okay, question number 16. Our HOA has received a request from a difficult owner for all contracts. We have 2 full-time employees under contract. Do we have to disclose employee contracts? So short answer is yes. You do under the statute, but you can redact compensation under the law if you want to. So you're saying, is it appropriate to redact compensation? You can, but you don't have to. The comment is, this owner's targeted our staff. The owner wants this person fired, but there isn't any cause for termination. We've repeatedly stated no to releasing staff compensation. We reference your cheat sheet, which says employee compensation should not be given out. Okay, so you don't have to give it, right? That's the bottom line. You can redact it. I will say this, there's other places they probably can find it. Like they can look through the check register, they might be able to determine that on the year-to-date budget too. So think about that as you're navigating this, right? There's other places they may be able to find it. I'm always inclined to say, don't play hide the ball, just give it to them. It is what it is. We don't want people to think that we're hiding anything. We need to be transparent. But if you want to, you don't have to share it. Okay, next question, number 17 from a board member. Are there any legal restrictions in an HOA in using the reserve funds? For instance, when an unforeseen budget impact occurs. So a lot of good questions on reserve accounts today. We talked about this just very briefly a few minutes ago. Check with your CPA. If you, want to borrow from the reserve fund because you have a problem with the budget, you're over budget on something. I have seen associations do it. Typically, they check with their CPA to find out the specific way to do it. It's not advisable, right? It's not something that I'm suggesting that boards ever do, but sometimes desperate circumstances require desperate measures. So check with your CPA. They'll probably say you have to return the money within the same fiscal year, but check with them just to be sure. Okay, next question, number 18. Our HOA has been given a copy of an amendment to another HOA CC&Rs, which states that after the date of the amendment, an owner must reside at their purchased lot for 12 months before the lot can be leased, and that the initial lease term is for 12 months, a minimum of 12 months. Okay, so let's see. The CC&R amendment was not notarized and filed electronically with the Maricopa County Recorder on March 24th, 2022. Is this amendment enforceable under Arizona law? This is like a bar exam question because there's all kinds of issues going on here. So, okay, first things first, I highly doubt that something was in fact, actually it says the amendment was notarized. Okay. So is it enforceable under Arizona law? So, there's a 6-year statute of limitations to sue an association for any breach of contract. So it's enforceable until somebody challenges it, right? And says it's invalid. A court says it's invalid. I don't like these types of amendments because first couple of reasons. First, there's a new case that was decided about a year and a half ago, 2 years ago, called the Callaway case, that talks about when amendments to CC&Rs, are they valid or invalid? They have to be reasonable and foreseeable. Just that's like the 30,000 feet view on that case. And okay, so I'm wondering on this particular amendment, I'd have to look at the CC&Rs for that association to see if this is the type of thing that would be foreseeable based upon what the prior language said. So it's really hard for me to comment on that. Now, just commenting on the section in general, because I kind of feel like maybe you're asking, hey, can this work for our association? Is this something that we can do? Maybe you can. Probably the most challenge-free way to do it would be to grandfather all existing owners and then make it clear that any current owners or any buyers that would buy in the future, they would be subject to this law, and any current owners, wouldn't be subject to it. That's an easy way to not get sued, to have a grandfather clause. I'm guessing, though, that if this passed, the homeowners aren't objecting to it. So that's a consideration too. Sometimes we run a test balloon of language like this to our owners prior to an amendment to see if they're opposed to it or in favor of it. And if you have the votes to pass it and you don't have anybody objecting to it, you probably won't have any issues under the Callaway case. This is kind of a complex question to ask because I don't have any of the documents and I think I know what you want to do, but I'm not quite sure. So you really should consult with an attorney if you're thinking about doing this amendment that is well-versed in Arizona HOA and condominium law. Okay, question number 19. I'm looking for guidance for homeowners using their property as an Airbnb. There are no guidelines in the CC&Rs. Is there a license fee to be paid to the city, state, and HOA? Yes, definitely. There's a bunch of requirements that you need to follow. I know the name of your association that you put in here, but I'm not exactly sure which city you live in. So I would start with a couple different things. I would contact your city, and most cities have this information actually on their website already, and ask them, for more information about, do they have, specific requirements for short-term rentals? There was a law passed several years ago that gives the cities, towns, and municipalities the right to pass ordinances. Most have in Arizona. So start there. Go to your city, find out, what do I need to do if I want to have a short-term rental? Also, you need to be registered with the county as a short-term rental, or any rental needs to be registered. So the city should be able to tell you about that, but you also may want to contact the county assessor's office on that as well. Okay, question 20. Do the new changes regarding political discussion with other members allow free and open discussion regarding changes in the operation of the board? Absolutely, yes, it does. So regarding the new law that was passed that allows for informal meeting of owners on association property, absolutely, that's something that you can talk about. Question number 21. Our association has no paid employees and owns no facilities. Our common areas include only our interior roads and drainage system. We have insurance that includes a commercial crime section that covers every board member as an employee, and the coverage is described as an employee dishonesty with a limit equal to or greater than our total cash on hand. A member has suggested that we consider bonding our board members instead. What are the pros and cons of bonding versus fraud and crime insurance? Honestly, I'm not sure that you can even bond. Typically, the licensing and bonding is for like contractors, to finish a project. So I'm not sure technically that that's exactly what you would call it. I think the best way to handle it is the way you're handling it right now. You have a fidelity bond, but I think it's always great to get, feedback. This is a board member asking me this. And so what I would recommend is you get your insurance agent on a phone call with you, your board, and you talk through this issue and make sure that you have enough coverage in the event that something bad should happen, where there's employee dishonesty or theft or fraud by a board member. It sounds like you don't have an employee, but make sure that you have the coverage you need for the concerns that are being raised. Okay, next question. Let's see, which one are we on? We also have a really good cheat sheet on insurance that my office should be sharing with you shortly. So I encourage you to take a look at that as you are navigating this problem. It describes all the different types of insurance that are out there. The other thing that I would really recommend that you look at is our cheat sheet on theft and fraud of association funds. I'm not sure we're going to have time to share that with you before we move on to the next question. But you can find that cheat sheet on our website at mulcahylawfirm.com. And that just gives you all the warning signs for theft and fraud and things you need to be aware of as a board member to ensure that that doesn't happen in your community. Okay, next question, number 22. Our rules and regs dated 3 years ago and adopted by the board only state late fees are charged 20 days after the first of the month's due date. Our bylaws adopted in 2023 state 10 days after the first of the month for late fees. The new board is electing to ignore the bylaws and go with the rules and regs. Do the bylaws that have been adopted after the publication of the rules take precedence? Our president says he's unaware of why adhering to the 20th of the month is not harmful to our membership, operations, or longevity, and in the spirit of being reasonable to our membership, must adhere to the more lenient date in our documents. Okay, so I don't know if you're a planned community or a condominium. So that's kind of important. If you're a planned community, there's a set late fee under the law. And that is that the assessment is due, it's past due after the 15th day of the month. So if you are considered technically a planned community, that's going to be controlling. If you're a condo, it doesn't have a specific date as to when it's, past due, the assessment. So you have to look to your documents. And in that case, your bylaws trump your rules in terms of what state law says on which documents have precedence. The board, should be following the bylaws. Now, I totally get it. I hate this question because I like what the president's saying because they're trying to be reasonable and lenient. I totally respect that. And it's refreshing to see something like that. But the bottom line is, from a legal perspective, they should be going by what their bylaws say if they are, in fact, a condominium. Okay, next question. Let's see. Are we required to record meetings and post those recordings routinely on our website? If the official record of a board action is the approved minutes, then what is the purpose of the recordings? You are not required to record board meetings under Arizona law. And you're not required to post the recordings on your website. And you're correct that the official record of the board is the approved minutes. I guess your question is, what's the purpose of the recordings? I mean, it's just, there was a law passed maybe a decade ago that said that owners have a right to record board meetings, either video or audio, if they so choose, and the board can't prohibit it. The board can pass rules on this if you want to, and we have a cheat sheet just basically entirely on this subject. So go to our website. It talks about board meetings and recording of board meetings. Owners have a right to do this, okay? If the board wants to be the official videographer or the official person that audio tapes board meetings, then the board does have to make the recording. Like, let's say they don't want the owners to videotape or audio tape a meeting, and they say that, then the board has to actually do it and then provide it to the membership if they ask for it. But you don't have to post it on your website, or you don't have to send the recording to everybody after the meeting. Now, if somebody asks for it, then yes, you do. Okay, next question. Number 24, from a board member. After properly notifying an owner of a fine and being given an opportunity to respond, is it levied in the executive session or in the open meeting? I think that the question is, when do we vote on this? So I guess that's kind of the question. So we've noticed an owner of a fine. So you've given them the written notice. You've given them an opportunity to respond. And remember, in the opportunity to respond, you can do that in the executive session unless the owner wants it in the open session. Then you have to move the owner's opportunity to respond, so to speak, to the open session if the owner wants it. Then do we make that decision in executive session, or can we do it in the open meeting? You can do it in either. You have a choice. Okay, next question, number 25. Reporting board meeting minutes. My association doesn't record motions and approvals in detail. Who makes the motions? Who seconds it? The name of the board, name members of the board members who voted yes or no. Requirement or spec for repairs is unknown. Is there a form regarding motions and approvals for the minutes? This causes a lot of problems from one board to another board when changes happen, and we don't understand who approved what and who. Okay, so we have a good cheat sheet on this. Go to our board meetings cheat sheet. I think if we have time, maybe my office can share it quickly here. Otherwise, you go check it out on our website at mulcahylawfirm.com. In that, I have a summary of how to take perfectly proper meeting minutes, and which is this question is all about meeting minutes. What do we have to include? I do say that whoever makes a motion and whoever seconds it should be listed in the meeting minutes. I don't typically require, though, that you list everybody's name, who voted yes and who voted no. Now, with the exception to that is if somebody asks for a roll call on the vote, then you would have to. Somebody, meaning a board member, says, no, I want a roll call on this vote. And typically that happens when there's like a big issue, like levying a special assessment, and there's dissent on the board. So they want the minutes to reflect that, hey, I was voted against this, and that's fine. And so other than that, we typically don't have that level of specificity for every vote, who voted which way on each vote. And most votes, honestly, are unanimous on a board anyway. So your board's just going to have to navigate that after looking at our cheat sheet on board meetings would be my recommendation. Okay. Okay, moving to the next question, number 26. What do we do when a board member wants to use her position to impose a controversial request for a special accommodation which may affect the community appearance or costs to maintain the property? Oh, gosh. Well, remember that a request, I don't know if this is coming. It sounds like this person's on the board and they're making a request for a special accommodation. I don't know if this is like a fair housing thing. Like maybe they want to have a ramp put in at the pool, or maybe they want to have a ramp at the clubhouse or the curb cut at the mailboxes. I don't know enough detail about it. So what do we do when the board member is trying to force something, right? Well, I think we remember that a majority vote makes a decision on all board decisions. So listen and determine what's best for your community. Now, if the person is trying to strong arm it, that's a whole different situation. You may need to get your attorney involved to help you navigate that situation. Okay, moving on to the next question is number 27. I have read the provisions for a closed board meeting and for an emergency board meeting, but is there a provision for an emergency executive board meeting, specifically where emergency meeting discussion would not allow for the 48-hour notice or for the minutes to be read and approved at the next regular meeting because of confidential content? I think that there are times where there might be an emergency executive session meeting. Something that pops into my mind would be like we're involved in litigation. There's a settlement offer on the table. We've got a short timeline to respond. And so we suspend the 48 hours notice. And how you would do it is just like you would do it for a regular emergency board meeting. We take the minutes. And at the next executive session for the board, we just approve those minutes from the emergency executive session. Number 28, if my CC&Rs do not specify a deadline for responding to an architectural request, is there a legal definition? Is there a legal timeline to respond to that under the law? So no, your documents would be controlling on that. So you respond within a reasonable time would be what I would say. So if you are leaving this out there for 6 months, that's not going to be considered a reasonable time by a court. So you have to act in a timely manner. But if your documents don't say 30 days, or 40 or 45 or 60 or whatever, just try to do it within a reasonable time period. And if there's going to be a delay because you can't get a quorum or you have more questions, deny it, right? Because if you have more questions, deny it and say, hey, submit this so then we can answer it in a timely manner once you get us the additional information. I really don't like it when boards leave architectural requests just sitting out there, not answered, because you need more information or because you don't understand it, because it's just a liability. It looks bad. So it'd be better just to deny it and ask for more information and then have them resubmit it. But bottom line is just try to, if you don't have a requirement in your documents, just try to answer it as quickly as possible, but in a reasonable time period. And I would say no more than 60 to 75 days. And if you are going to do that, tell them why. Or if you're denying it because they don't have enough information, just deny it and then move forward. And then ask them to resubmit. Okay, question number 29. Second, this is in regard to the board minutes. When there is a major disagreement on an issue, particularly affecting membership, should the reasons for disagreement be documented? Are the dissenting board members liable if there's potential litigation because the minutes do not discuss the details of their disagreement? Okay, really good question. So this happens in boards, right? You don't always agree on everything. And a little bit of healthy opposition is good in any situation because you look at it from all angles. So do we have to have the minutes be 10 pages long outlining the reasons why we don't want this? No, the minutes really shouldn't do that. But this might be the time where you do the roll call vote, where you vote against it and the person's names are listed. Can the dissenting board member not be liable if there's litigation? Well, unfortunately, no, because typically the association is sued, right? And in the cases where the association is sued, usually individual board members are not named in litigation. It's usually the association. So that's kind of the bottom line on that. So I hope that answers your question. I just don't like to see 5-page meeting minutes with things that everybody said. It just doesn't make sense. And actually there's some liability with that too, in terms of Sometimes it's just not good to have all that information on there. You just want to have what was decided, and the roll call is a good pivot for you. Now, as a board member, if you're really upset about something, you always can write a letter to the board after the meeting and say, hey, I'm upset about this and this is why, and I'm asking this be included with the records of the association. Okay, we are on question number 30. Looks like we have about 13 more questions, 43 questions total. Okay, question number 30 from an owner. Our CC&Rs state 1 pet per household. There is one household that submitted years ago paperwork stating that one of their dogs was a service animal. That dog is recently deceased and the owners have acquired another dog. It was implied when the owners submitted the paperwork for the new dog, that when one of the dogs was gone, they couldn't replace the animal. Do the owners have to submit new paperwork from their physician stating the need for a new service animal? So yes, we have a cheat sheet on this topic called Pets in Your Community Association. We also have the federal cheat sheet that our firm puts out that talks about assistance animals. Here's the bottom line. Be careful on this, because if somebody needs an emotional support pet or somebody needs a service animal, the association under federal law can't prohibit it as long as the resident provides the requisite documentation, like a letter from their doctor stating that they need this, etc. So, saying that once one of the dogs is gone, they couldn't replace the animal. I don't know enough about that situation to even comment on that, but you need to look at this going forward. So if they submit the new paperwork that complies with the Fair Housing Act and they are entitled to an assistance animal or a service animal, the association is very likely going to be required to allow that dog. Okay, next question from a committee member, number 31. We are in a planned community. Can we require owners to follow Arizona Register of Contractor rules, or do we have to go only by what's in our documents, which do not require using licensed contractors? Okay, great question. I'm guessing maybe this committee member might be on the architectural committee. And so I think it is helpful, and I'm okay with this, saying when you do an approval, saying that this project needs to be, completed by a licensed and bonded contractor. And I would do it this way and say, if Arizona law requires it, this particular or whatever project needs to be conducted by a licensed and registered and bonded contractor. And so can we require them to do that? State law requires them to do that. So I think you're well within your rights to put that sentence in your approvals if that's something you want to do. Now, let's say you don't put it in there and they're using, like a handyman to do a major renovation at a home. You can just contact the Register of Contractors, make a complaint about the handyman, and they'll investigate it for you. Question number 32. When a landlord wants to transfer their clubhouse privileges to allow tenants to access the clubhouse facilities, are there limits on what the HOA can charge the landlord? Okay, so this is an unusual question. So we've got a landlord who's an owner landlord who's not living there. They want the tenant to be able to use the clubhouse. Are there limits on which the HOA can charge the landlord? Well, I think they just need to charge whatever they would charge an owner normally. Typically, tenants have the right to use the common areas in an association. So we can't treat them any differently than we would treat another resident. And we can't do like an add-on charge to the landlord for allowing the tenants to use the clubhouse facilities. But typically, I just got this question yesterday. Just somebody who called in just had a quick question for me was, hey, can the landlord still use the clubhouse facilities if they're not living on the property and they have a tenant in the property? That's an interesting question. Probably not, but that's a good thing that you should be talking about, with your landlords when they're leasing their properties. Okay, question number 33 from a board president. A contractor was hired and our HOA property manager overpaid the contractor by over $1,000. The contractor passed away shortly after the job was completed. Our property manager is refusing to address this matter. Shouldn't the property management company be responsible for paying us back? They're refusing to talk with us about this. This is an unfortunate situation, right? It's unfortunate that the manager overpaid. It's unfortunate that the contractor passed away. I think what you need to do is, the manager obviously is refusing to do this, right? Because they don't want to get trouble. So I think you just need to escalate this, go up higher in the food chain and talk with the manager's boss. Explain to them what the situation is and then see, if they're not willing to pay it, it's a problem, right? Obviously the contractor's deceased, so that's going to be a dead end getting the money from that. I think it's indicative of whether the management company is honorable if they don't pay you back on this. It was a mistake. They should correct it. Would be my feeling. If my firm made a mistake like that, we would correct it and make it right. Give the association the money back. Okay, question number 34. From a board member, our planned community is an independent sub-association within a larger complex of 12 independent sub-associations, each with its own governing documents. A master association coordinates the matters affecting the 12 sub-associations. Rules and regulations are amended by the 12 in diverse ways. 8 sub-associations either have no rules or regulations or state no requirement for amending them. 2 sub-associations amend their rules and regulations by simple board adoption. 1 sub-association requires a majority vote of the members. Only our sub-association amends the rules and regs affecting common areas by board adoption, but requires majority vote of the members for rules affecting members' private property. This seems cumbersome, but is it advisable to require a majority member vote for rules affecting members' private property? All our architectural and landscaping guidelines are simply adopted by the board, although they too affect members' private property. I think this is kind of a loaded question because I don't know how extensive your rules are. Every association handles this differently. So some associations allow the board to pass very broad rules without membership approval. That's easier, obviously. So from a practical get it done standpoint, that's going to be easier. Some associations rarely require a homeowner vote for, rules that are more particular to the owner's property. So it's kind of unusual that your association has something like this. But I want to say just one more thing in that if it's something that you're doing on regulating an owner's property, it really probably should be in the CC&Rs and not in the rules. Okay, question number 35. From a board member, a realtor calls for a prospective buyer in the community with a question that would require an architectural review. How does the association answer this question without implying the request is being approved and not discourage an offer on the property? I don't like it when this happens because it always is a sticky wicket, right? So we never talk to the prospective buyer or the realtor if they want some information. Our obligation is only to the owner. So the owner, the realtor should go through the owner. And if the owner wants to make a formal request, that's the way that this should be handled. We don't give pre-approval on requests or anything like that to owners. Okay, next question, number 36 from a board member. What recourse does the board have if an owner continually harasses the board through emails and discussions with our residents, where the owner quotes multiple ARS statutes, so the email looks very official on the surface. However, the statutes don't really have anything to do with their unfounded complaints. Unfortunately, not all owners know this, and they don't check the statutes. At the end of the day, these comments are slanderous and libelous that are patently false or misleading. The board is tired of dealing with this behavior. I totally get this because, like I said, I've served on my board for 10 plus years and I've had this happen while serving on the board. I mean, it's a problem because it takes so much effort to correct the misinformation that's being communicated to your community. But you have to do it. And I'm not going to lie to you, it burns board members out. It burned me out when I was the president, when I had to do this often because I had one person in our community who was just spreading misinformation like crazy. I mean, I think there's 2 ways to handle it. Either you ignore it, but recognize that can boil over if you continue to ignore it, or you just address it very briefly. We became aware that an owner is sending out paperwork on this particular issue, and we just want to set the record straight. We've talked to our attorney and here's what's going on, and move on. Okay, next question, number 37. Governing documents say nothing about a reserve fund. Under cash accounting, if the financial statement shows a loss at the end of the fiscal year, can you legally transfer money from the reserve fund to the operating statement so that the association shows a break even? Do you have to pay that amount back to the reserve fund at any point? This is a really good question for a CPA because I'm not a CPA. I think it is problematic that at the end of the year, you don't have enough money. But we do see this from time to time. And I do think that sometimes they do move the money around from the reserve and then they have to pay it back within a certain time period. So talk with your CPA about this and see what he or she says. Question 38. Over the course of the last summer, we had several infractions and violations of our pool rules and code of conduct. In the past, we have not required our community members to sign an agreement regarding our pool rules in order to receive a pool key. But after consulting with our insurance agent, he agreed that it would be a good thing for us to do that to limit our liability and our risk. Can we require our community members to sign and agree to the terms of, using the pool rules and the code of conduct, as well as a release and waiver of liability and indemnity agreement? Ooh. Yeah, it's a good way to do this is just rekey the pool, right? And then to get the pool key, they have to sign this. But okay, a couple of things. I mean, they're already subject to the pool rules based upon the association's documents. So, making them sign and agree to it is not going to add to our enforceability. It's just going to make them aware, hopefully, before they sign it, they read it, that, hey, oh yeah, we can't bring glass to the pool. Oh yeah, we can't have more than 10 guests at the pool. If you're doing it for that purpose, of course, that's fine. But you already have the right to pass rules, I'm assuming, in your documents. So it's not like you're creating a new obligation here by having them sign it. The code of conduct, same analysis. The release and waiver, I mean, of course, it's great to have that if you can get them to sign it, but it's probably will not uphold in court. But if you have it, it might deter them from filing a lawsuit. If somebody gets injured, probably not. But it isn't something that we typically see boards doing for people who are just using the pool as a regular owner. And they could totally refuse to sign that too if they wanted to. And you would still have to get them the pool key. Same thing on the pool rules and the code of conduct. Really, we can make them aware of it, but we can't require them to sign these documents. Okay, number 39. If the board has already voted against a motion, can the motion be introduced at a later board session? Yes, it can. And that does happen frequently. Question number 40. But remember, for it to move forward, you got to get the second. So if people don't want it, it's not going to get a second. It's not going anywhere. Okay, question number 40. The current HOA rules and regulations state the pool hours are 7 a.m. to 11 p.m. There is no mention of solar covers. The pool is 3 times the size of a normal pool and requires 2 solar covers. Years past, an owner would uncover the pool prior to 7 a.m. Now a board member has decided that we need to save money and doesn't uncover the pool until 8:30 a.m. Residents are told the pool is open, but they just have to uncover it if they want to use the pool. We are a senior community and most are incapable of winding these long covers up. Until there are amendments to the rules and regulations regarding solar covering times, should the pool be uncovered at 7 a.m.? The solar covers obviously are a great idea because they keep the pools warmer. I mean, I guess one board member shouldn't be making this decision. This should go back to the entire board. So I would ask to have this voted on in an upcoming board meeting so that there can be a proper discussion of this. That will be my number one thought. My second thought would be that there should be a crew that removes these solar covers. It should not be residents ever doing this. And I worry that if they aren't uncovered, that someone might get in the pool and try to swim under it or around it or something, which would be very dangerous. So I think your board really needs to reevaluate this. If the pool opens at 7, those pool covers should be rolled back at 7. It's my opinion. Okay, question number 41. Is it unethical and or illegal for current and those seeking to be elected on the HOA board to hand collect board member election ballots when the ballot specifically states that the ballot is confidential? Is it unethical or illegal? I don't think so. Any resident or any owner can collect ballots unless the documents don't allow for that. Sometimes the documents say that the ballot has to be mailed. That may be the workaround on this if you don't want board members collecting it. Mailed back by a certain time, and then owners, if they don't mail it back, can vote in person. So is it unethical or illegal if the ballot doesn't prohibit it? No. Question number 42. Our HOA complex is owner occupied. Since the property is in a trust, we were told their son was able to live there. The parents live in a different property, not part of our complex. The son now wants to be on the board. The property is listed in his parents' names with TR. Is he eligible to be on the board or only his parents? Thank you. Okay, so board eligibility is going to depend on what your bylaws and your CC&R say. It says since the property is in a trust. So I would get a copy of the deed, number one, see what's the name of the trust. And it's probably in the parent's name, if I had to guess. And now the son wants to be on the board. I guess the property is named in the parents' names, you're saying, with TR. I'm assuming that's for trust. So I don't think he's going to be eligible to be on the board, but I have to look at the deed and I have to look at your bylaws to give you a formal opinion. Number 43, where can I request the legal language for a petition to collect signatures to keep control of parking streets within our community? I may have this wrong. I think it was House Bill 2899. Okay, so where can you find the legal language for petition? You're going to need to get a lawyer to write it for you. And that's my best advice to you. You need to hire somebody so that you do it correctly, because the worst thing to do would be to not get the signatures that you need. But remember, basically, I'm not sure that doing a petition is also the right way to handle it, because technically, you need to have a meeting of the membership to vote on this. Maybe what you're saying is your board saying, hey, we're not going to have a meeting. And now you're trying to petition the board to get a meeting. I don't know. The petition would be to call the special meeting, not to vote on whether to keep the streets, control of the streets with the association. That would have to be done through a formal vote at a meeting of the membership. And the date on that, I couldn't remember it before off the top of my head, but you're going to need to have, let's see, I don't think my office put the exact date in there. I think they just copied part of it. So sorry to reference that. But so I think what you do need to do, here we go, it is no later than June 30th, 2025. You would need to have that vote. Okay, question number 44. A board member, in a criminal nuisance at a long-term rental situation, is 6 months after the most recent known police activity too long to encourage the owner to evict the tenant? Probably. I mean, I don't know how serious the issue was, but if you waited 6 months and there hasn't been anything else, probably it is too long. And we can encourage, of course, but the landlord has to go into court to evict the tenant, and they have to have the evidence that this person is, violating whatever the lease or the association's rules or whatever. And waiting 6 months could be something that would prohibit them from getting that eviction order. I don't know how serious it was. Have to know more of the facts, but delaying that long, might be something that would detrimentally affect their ability to evict the tenant. Okay, we only have 4 more questions. Number 45, how can HOAs manage group homes in their communities in light of the recent sober living homes fraud controversy? So my great office has done a little research for me so I can answer this question. So there was a recent discovery of fraudulent sober living homes across the valley related to Medicare fraud. Some homes are unlicensed, and a young patient recently, unfortunately, died in one of these sober living homes. Okay. How can we manage the group homes in light of the recent sober living homes controversy? Well, basically, what you would do is if you feel that a group home is not legitimate, be careful how you handle it. I think probably what you would want to do is go back to the city and just express your reservations that, hey, can you please look into this? I'm not sure that this actually qualifies as something that would be allowable under the group home exemption under the Fair Housing Act, and let them do the research on it. Another way that you could approach it would be to contact the owner and express any concerns, but I would not do that without having your attorney write the letter. Okay, number 46, we have in our documents 55 and over and owner occupied. There's a lot of discussion about what that means. Can we come up with some guidelines instead of changing the CC&Rs? I think you really need to reach out to your attorney to talk about this. It's pretty straightforward. If you're a 55 and over community, at least one occupant has to be age 55 or over. If you are owner occupied community, meaning that, there's no rental, that may be more complicated because you can't change the guidelines if the CC&Rs, say something different. They allow rentals or whatever. So this is something you should talk to your attorney about. Okay, question number 47. Are CC&Rs changes active when the change has been signed or after they have been recorded with the county recorder? Great question. So they have to be recorded. That's when they are officially able to be enforced. You also need to notify the membership of the changes to the CC&Rs and provide them with a copy, whether it's on your website or whatever. Okay, question number 48, the last question today. I am a new board member. Can the board meet to discuss positions and goals for the next year without that being considered an open meeting with required notification? So short answer on that is that must be an open meeting. Unfortunately, that's just the way the law works. Anytime a quorum of the board is discussing association business and it's not an executive section topic, it needs to be an open board meeting. Okay, that's it for today. February is going to be a really busy month for all of us. Not only do we have Valentine's Day, but we also are going to be teaching in-person class with the Scottsdale Neighborhood College on Tuesday, next week, Tuesday, February 6th from 1 to 3 p.m. And we're going to be talking all about committees. How do committees work? Architectural committee, what are the requirements for committees? Do they have to follow the open meeting law? So it's going to be a great in-person class. If you want more information about it, you can go to our website at mulcahylawfirm.com or go to the City of Scottsdale website to register. Some other important things that we have is we have another virtual class that we're going to be teaching. But before we do that, we have a tech class with the City of Goodyear, which is going to be a virtual class, a roundtable. And that's going to be on February 15th from 5:30 to 7 p.m. And this is just an opportunity for Goodyear residents to talk about different things that might be on their mind regarding HOAs and condominiums. It could be board members, homeowners, property managers. 3 topics that I've been asked to talk about are financials, election requirements, and reserve studies. So if you're interested in hearing more about that, you're welcome to go to our website at Mulcahy Law Firm to hear more about that. And last but not least, we have our class number 2 of the Virtual HOA Academy, which we've been teaching now for 3 years, will take place on Tuesday, February 20th, 2024. It's going to be a virtual class like it always is from 11 to 12 a.m. or from 11 a.m. till 12 noon. The topic for February's class is going to be mastering HOA and condo board meetings. We're going to be talking about annual meetings and regular board meetings, and we're going to cover everything you need to know on how to have a successful annual meeting and how to run your board meetings. And so we hope you'll join us for that class, that virtual class. Looks like we had a really great attendance today. I looked at different times during the presentation. Looks like we had over 60 people joining us on Facebook Live and on Zoom. So thank you so much to everybody for being here today. Look forward to seeing you at our future classes that we have in February. Like I said, it's going to be busy. We've got 3 more classes that we're going to be teaching in February. And I wish all of you a very happy Valentine's Day. So take care, everybody. Have a great weekend and look forward to seeing you on one of our next presentations. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.